For months, I've been calling on Secretary Noem to answer for the lawless and inhumane reign of terror her agency has unleashed on America. Secretary Noem has such a busy schedule that she was unable to come before this committee in the last calendar year. But now, she said she might find time in her schedule to join us in a mere 5.
This may look like a routine oversight complaint, but it's actually a warning flare about constitutional balance slipping out of reach. What's really being tested here is whether Congress still has the authority to restrain executive power when surveillance tools expand faster than accountability mechanisms. This raises broader questions about who answers to the public when national security is invoked as a shield against transparency. In this video, we'll break down how a single absence exposes a deeper failure of democratic oversight and why the stakes extend far beyond one hearing room.
Durbin. Thanks, Mr. Chairman, for holding this hearing. In less than 3 months, 702 will expire. As a committee with jurisdiction over FISA, we have a responsibility to conduct oversight and to craft solutions that protect security and the constitutional rights of Americans. Given this responsibility, I am disappointed that we do not have any witness from the Trump administration testifying today. Members of this committee should be allowed to publicly question executive branch officials regarding their use of this sweeping authority, especially for warrantless surveillance of Americans. That's why when I served as chairman of this same committee, I convened a hearing with senior officials from the Biden administration so that they could be interrogated publicly and the public could hear their answers. The failure of the Trump administration to appear before this committee on important issues is a troubling pattern that must come to an end. For months, I've been calling on Secretary Noem to answer for the lawless and inhumane reign of terror her agency has unleashed on America. Secretary Noem has such a busy schedule that she was unable to come before this committee in the last calendar year. But now, she said she might find time in her schedule to join us in a mere 5 weeks. What's going to happen in Minneapolis in the next 5 weeks? When you look at the past 5, it's a legitimate question. With the Trump administration challenging our constitutional rights and the sunset of Section 702 just 3 months away, a hearing with government officials to address the use of surveillance is imperative. Section 702 grew out of a secret, warrantless surveillance program under the Bush administration. When this illegal program was exposed, Congress responded by authorizing a new authority known as Section 702. It allows the government to collect communications of foreigners located abroad without a warrant or court order for the purpose of collecting foreign intelligence. There is no doubt that Section 702 is valuable. However, for years, the government has used it as a domestic spying tool to collect millions, maybe billions of Americans' private communications. And it's in searching these vast troves of these communications, reading our text messages and emails, and listening to our phone calls, all without a warrant required by the Fourth Amendment. Section 702 has been abused to spy on business and religious leaders, political parties, members of Congress, campaign donors, journalists, and political protesters of all stripes. In passing the Reform Intelligence and Securing America Act in April 2024, Congress codified modest measures to reduce these abuses. But RISA also weakened other safeguards and greatly expanded the scope of 702. It is my view, when 702 was authorized in 2008, and it remains my view now, that this section does not contain sufficient safeguards to protect the privacy and civil liberties of Americans. That is why, since the first reauthorization of FISA in 2012, I've worked on a bipartisan basis with Senator Lee, and we continue to work together to require a warrant for the search of any American communications. I urge my colleagues to join our effort. I look forward to working with the chairman to ensure that Congress does not fail the American people.
Would you like to introduce your person?
Thank you. Chairman has asked me to introduce the minority witness, and I'm sorry I have to leave after I do that. But it's my pleasure to introduce the minority witness, Liza Goitin. Liza, I hope I pronounced your name correctly. Is that close? Okay. Ms. Goitin is Senior Director of the Brennan Center for Justice, Liberty, and National Security. She seeks to advance effective national security policies respecting constitutional values and the rule of law, nationally recognized expert on presidential emergency powers and government surveillance and secrecy. Testified before this committee before, she served as counsel to this committee's Constitution Subcommittee and a trial attorney in the Justice Department. Graduate of Yale Law School and a clerk in the U.S. Court of Appeals for the Ninth Circuit. Welcome back.
Thank you, Senator Durbin, and welcome, Professor Goitin. I'd like to introduce Mr. Stuart Baker. Mr. Baker has extensive experience in government and the private sector, including as a law clerk to U.S. Supreme Court Justice John Paul Stevens, Mr. Baker also served as general counsel to the National Security Agency from 1992 to 94 and later as first assistant secretary for policy at the Department of Homeland Security. Mr. Baker testified before the September 11th Commission on Intelligence and Law Enforcement Issues. His expertise in this area makes him particularly qualified to testify here today. And then Professor Adam Klein is a subject matter expert on counterterrorism, intelligence, and government surveillance. He currently serves as the director of the Robert Strauss Center for International Security and Law at the University of Texas. Mr. Klein previously served as chairman of the United States Privacy and Civil Liberties Oversight Board, where he conducted oversight of the intelligence community, including Section 702. Mr. Klein served as a law clerk to U.S. Supreme Court Justice Scalia and Judge Brent Kavanaugh when Kavanaugh was still on the D.C. Circuit. His legal and policy expertise are a nice asset to this discussion. Before you testify, I would like to make a comment that would follow up on the administration not being here to testify. Congress is an Article I branch of government. This essential program is set to expire in just a few months, and it's our job to reauthorize it. Today, we're hearing from experts with diverse views and experience, including government experience directly relevant to the program. For my part, I'm offering legislation and holding this hearing. Congress set the reauthorization clock the last time it passed in 2024, and we need to meet our own timeline. If the administration would like to brief us in an open or closed setting.
The moment lingered in the room after Senator Dick Durbin finished speaking, not because of a dramatic outburst, but because of what was missing. An empty witness chair, a vacant seat where executive branch accountability was supposed to be. Durbin didn't raise his voice. He didn't need to. His words carried the weight of an accusation far more serious than a personal jab. When he noted that Secretary Noem's schedule somehow couldn't accommodate Congress, even as constitutional authorities approach expiration, the message was unmistakable. Power was being exercised without explanation, and oversight was being treated as optional. This was not just a procedural complaint. It was a warning. With Section 702 nearing its sunset, the senator reminded the committee and the country that surveillance authority does not exist in a vacuum. It exists within a constitutional system designed to restrain power, not concentrate it. And yet here we were, months away from expiration, with no administration official present to answer direct questions. No public testimony, no accountability in daylight, only silence and delay. Durbin's remarks pulled the camera back to a deeper truth about modern governance. Oversight is not a courtesy extended by the executive branch when convenient. It is a requirement. Congress is not a spectator to executive power. It is a co-equal branch. When officials decline to appear, when they postpone scrutiny while continuing to wield sweeping authority, the balance envisioned by the founders begins to tilt. Not suddenly, not explosively, but slowly and quietly. Section 702 was born out of exposure, a response to secret programs that went too far, hidden from the public until they could no longer remain hidden. Congress acted then, attempting to draw a line between national security and constitutional liberty. But as Durbin made clear, lines drawn once do not stay intact without vigilance. Over time, authority expands, safeguards weaken, exceptions become routine. And surveillance meant for foreign intelligence begins to drift inward. What makes this moment so consequential is not the existence of Section 702 itself. Even its critics acknowledge its value. The danger lies in how it is used and how often it is searched without judicial approval. Durbin laid out the scope plainly. Communications collected without warrants, later queried for domestic purposes. Messages, emails, calls, all accessible without the protections the Fourth Amendment was designed to guarantee. This is not an abstract debate. It is about whether constitutional rights are treated as enduring principles or negotiable obstacles. Durbin pointed to years of documented misuse. Not speculation, not fear-mongering, but findings already acknowledged by oversight bodies. The names change, the administrations change. But the pattern remains disturbingly familiar. Extraordinary powers granted in moments of urgency, then normalized through repetition and distance from scrutiny. The absence of administration witnesses spoke louder than any prepared statement could have. Congress was there, on the record, wrestling publicly with the consequences of its own laws. Experts with opposing views were present, prepared to testify under oath. But the officials who actively used these authorities, the ones who could explain, justify, or defend their decisions, were not. That absence raises a question larger than Section 702 itself. What happens when executive power grows accustomed to operating without immediate challenge? What happens when accountability is delayed until after decisions are made, records sealed, and timelines conveniently extended? History offers an answer, and it is rarely reassuring. Durbin's insistence on a warrant requirement for searches involving Americans was not radical. It was foundational. It echoed the core idea that security and liberty are not mutually exclusive, that protecting one should not require sacrificing the other. His bipartisan work underscored something else often forgotten in today's political climate. Constitutional limits are not partisan preferences. They are guardrails. As the hearing moved forward, the weight of the moment remained. Congress faces a deadline it set itself. The clock is ticking not just on a statute, but on credibility. Will lawmakers demand transparency before renewing authority, or will they defer once again, trusting assurances given behind closed doors? Will the public be allowed to hear answers or only reassurances after the fact? This hearing was not about personalities or schedules. It was about responsibility, about whether power answers to the people through their representatives or whether it quietly insulates itself from scrutiny. Durbin's remarks cut through procedural language to expose a simple truth. Democracy does not erode only through dramatic acts. It weakens through neglect, delay, and the normalization of unchecked authority. In moments like this, silence becomes a statement, and absence becomes evidence. The question now is whether Congress will accept that silence or insist on answers while it still can. Because once authority is renewed, once the window closes, accountability becomes harder, not easier. Rights once compromised are rarely restored without struggle. This is the work of oversight. Uncomfortable, unpopular, essential. And it is why moments like this matter. If you believe constitutional limits still mean something, if you believe power should be questioned, not deferred to, then stay engaged. Watch closely. Demand answers. Subscribe to Liberty Report USA. Support our work to expose the truth.